Supplemental list, item number 1.
The earlier part, page 22, direction was issued to consider the case within 4 months. Within 4 months on the basis of order passed by the SO. Past time is in some allowed time to take instruction or development.
You see, ये बेंचटा सबुआडे नहीं तो आपण listed on 1710 and we on that day we specifically raised this matter today and obviously almost 2 weeks have passed.
A paper one just that I have already intimated over phone today. They provide.
No, what do you want?
Only to tell what development has been made, the consideration of what decision has been taken pursuant to annexure 2 at page 22.
So how it not been done?
They served an affidavit upon us. Served an affidavit alert today itself.
What affidavit?
Lordship, in A4 series.
They have served you an affidavit?
Lordship.
You have no instruction?
Not in file.
Let us see that affidavit.
It is there.
Because that is also not on record today. Where come you got it? He is not having the copy, neither we. Aji, file is. So it is content 7050 05, right?
7504.
Day before yesterday, of affidavit filed by opposite party number 4. Acha. Executive filed the contemplation alleging non-compliance of the order dated 8/4/24 when this from directed order to make direct purchase additional conformity with instructions. In compliance with the deponent on so and so on. Wrote several letters to the higher authority requesting them for necessary allotment of fund towards the cost of the land at least. That is resident keeping in good please to grant some more land. This for whom as to no quantum. He has stated here written letters on 4 letters he have already written. 25/9, 17/12, 28/5 and 17/10. So these letters copy has been annexed. This is the affidavit by the superintending engineer.
OP number 4, my lord.
OP number 4, right. Somebody else has come, so that is why he has
Higher
filed.
authorities are also made parties to the content petition, my lord.
No, it's all right. He has addressed this letter to whom?
To additional chief engineer, if I may not.
So that means no, the copy has been also forwarded to the collector. It has been forwarded.
Collector is OP number 2, my lord.
That copy has been submitted to the collector so and so and director, additional secretary. No, you see this content proceeding, they are to appoint the engage their own advocate. So we are issuing notice. Now let them face the music. This contempt petition has been filed by the petitioner Amresh Das for non-compliance of the order dated 18/8/2024 passed by this court in WPC number 5364 of 2020. When the matter was taken off first on 30/4/2025, we issued notice. We asked the Land and Council for the state made a submission that the file has been processed and you may be granted 10 days time to get the up-to-date instruction in the matter. Then the matter was listed on 8/8/2025. On that day, the Land Council for the state placed the letter of the Collector and District Magistrate Jajpur dated 13/12/2024 and also produced another letter dated 1/5/2025 issued from the London AG's office to so and submitted that response has been received and took further time to obtain instruction in the matter. The last time when the matter was listed on 17/10/2025 and the Land Council for the state sought for time to obtain instruction, the Land Council for the petitioner raised serious objection on the ground that 1.5 years have passed since the date of passing of the order, but the order has not been complied with. Accordingly, we directed the matter to be listed today, and the Land Council of the state was asked to obtain necessary instruction in the matter. Land Council for the state today also seeks for an adjournment. The Land Council for the petitioner submitted that he has an affidavit filed by one Rotnakar Dalai, Superintending Engineer, Irrigation Division, Jajpur, which is dated 29/10/2025, wherein the superintending engineer has stated that in compliance to the order of this court, he wrote several letters to the higher authorities, that is on 25/9/24, 17/12/2024, 28/5/2025 and 17/10/2025, requesting therein to for necessary allotment of funds towards the cost of the land acquisition of the petitioner. The said affidavit has not been placed on record. Let the registry place the same on record. In view of the fact that the order dated 18/4/2024 has not been complied till today, even though, as for the said order, the petitioner has made necessary communication to the concerned authorities and in spite of repeated communication from the Filling Engineer Irrigation Division Jaspur to different authorities, including Collector and District Magistrate Jaspur, Additional Chief Engineer Eastern Circle to Chandigarh, Director R&R cum Additional Secretary to Government, Water Resources Department, Odisha, Bhubaneswar, Engineering in Chief, Water Resources Odisha, Bhubaneswar, and Chief Engineer and Basin Manager, Mahanadi Brahmani, Baitarani System, Chandigarh. No response has been received. Either by the Land Council for the state or by the concerned superintending engineer who has filed the affidavit before this court. Issue notice to the contemners opposite parties as to why a proceeding under Contempt of Courts Act shall not be initiated against them for non-compliance of the order dated such and such by so and so. The Land Council for the petitioner shall file requisites, speed post requisites to proof of delivery within a week. Matter be listed, special. एटार गोटे एटा देखिबे मगेई देबे एटा फाइल हेइथिबो निश्चय जदि नले गोटे जेरॉक्स कॉपी रखबो हैना तांको देबे you just wait सब जेरॉक्स करिकिन तांको देबे फेरे दे मैडम. Yes, next item.
Item 2.
In item 2, your lordship, last occasion directed that regarding condonation of delay in filing contempt application. Yes, in para 4, it has been clarified that petitioner who is a old and ailing retired person living in financial distress condition is retired from service on 31/3/2014.
Period, it says about a particular period within which you are to file the contempt.
By 9/2/2005, I would have been filed.
Just a minute. You see, if we come to the order dated 5/12/2023,
Yes.
on the basis of which you have filing this contempt petition,
Yes.
then that was disposed of, and the direction was that opposite party number 2 to expedite the matter at his level and dispose of the grievance petition of the petitioner at an earliest, preferably within a period of 8 weeks.
8 weeks.
Hence means from that day.
Yes.
So obviously 5/12/2020 যদি আমি 8 weeks calculate করিবু তাহলে it goes to 5/2 কি এমতি এই টাইপর হবো 5/2. So 5/2 মানে ଆପଣଙ୍କର cause of action ସେବେଠୁ ଆରୋଜ କଲା ତ ତାହାର ବର୍ଷେ ଭିତରେ ଆପଣଙ୍କୁ ଫାଇଲ କରିବାର ଥିଲା ତ ଆପଣ ଫାଇଲ କେବେ କଲେ ଆପଣ
on 12/5/2025. So and it would have been filed by 5/2/2025.
You are supposed to file by 5/2/25, and that the contempt of court. Section 20.
Your lordship, kindly glance to my annexure.
No, question is, can it be condoned? That is the reason.
Yes, page 15. Page
also pointed out on that day.
Yes, your lordship is correct. I am placing the facts. Annexure 3, page 15. The contemnor write a letter to the law department for clarification whether it will be paid to the petitioner or not. Page 15. clarification regarding sanction of annual increment falling due on the very next date of retirement. And they have sought for the clarification from the law department.
Mr. Bahali, on that day also, we gave you time to cite some decisions.
Yes.
Whether the delay in such a case can be condoned at all. Whether
Yes,
we
my associate will just now hand over the S. Tirupati Rao versus M. Lingayappa 2024
where is your
judgment.
associate?
Is there.
Your associate is not here.
Yes, he is there. Yes. Kindly have a glance to the judgment.
The provision is section 20.
Yes.
No court shall initiate any proceeding for contempt either on the own motion or otherwise
Yes.
after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. So
Committed.
contempt is alleged to have been committed, let us say from 6th of 5 तारिख पर्यंत तांकर समय रहउची
Again.
6 तारिख रु आपनकर आरंभ हेरा 6 फेब्रुआरी. So 6 फेब्रुआरी आमे गोटे वर्ष जदि धरिबु, then how this let us see that decision.
Because it is a continuance wrong, and I will just place the judgment. 2 copies are there. I have provided 2 copies.
It on the Contempts of Courts Act.
Yes. ये page 20, para 28 of that judgment, it starts with para 28, page 14 of that judgment.
Just a minute. Yeah.
Having held that review jurisdiction was not available to be exercised by the division bench, reversal of the impugned order is the solitary conceivable outcome. However, the importance of the second legal issue cannot be overemphasized. The purpose of law of contempt is to secure public respect and confidence in judicial process. We have found the law on the question of applicability of the principles of continuance wrong, breach, offense for the purpose of section 20 of the Act not too certain. Hence, we feel it expedient to give a brief overview of the law of contempt and how such law has evolved and developed, as well as chart out of the course of action to be followed by the High Courts while exercising contempt jurisdiction, not only generally but also on the face of an objection as to the maintainability of a time-barred application initiated by a party for civil contempt. Then kindly have a glance to, I will straight away take to your lordship, page 40, para 41, page 16. Para 41, page 16. In Pallab set, a 3-judge bench of this court had occasion to consider whether the view taken by paragraph 41, page 16.
Just a minute. 41 to start is
one of the principle underlying the law.
one of the principle underlying the law of limitation. See that?
No, page 16.
16.
Page 16 again.
Para 41.
Para 41 no.
Oh, wait, true that's
Yeah.
right. 41.
ସେଇ ଯୋଉ para 41 ଟା ସେଟା related to other.
41 ଟା double number ହେଇଯାଇଛି ବୋଧେ.
Yeah.
ନା ଓଟା ସେ decision
ସେଟା
ନା.
decision ର
ଆଚ୍ଛା
41
ଆଚ୍ଛା
ସେଇଟା।
ଠିକ ଅଛି. ହଁ ପଢନ୍ତୁ.
In Pallab set, a 3-judge bench judgment of this court had occasion to consider whether the view taken by a 2-judge bench in Om Prakash Jaiswal so and so was correct. In on the Prakash Jaiswal, the bench had taken the view that filing of an application for petition for initiating proceeding for contempt does not amount to initiation of the proceeding by the court, and initiation under section 20 of the Act can only be said to be proceeding by the court and have occurred when the court forms the prima facie opinion that contempt has been committed and issue notice to the contemner to show cause why he should not be punished. Such view did not find favor with the bench in Pallab set. It was observed that a provision like section 20 has to be interpreted having regard to the realities of the situation, and that too narrow a view of section 20 had been taken in Om Prakash, which did not seem to be warranted. Then your lordship kindly have a glance to, I will take the next page, also same 41. Page 41 in between, in the middle part, relevant part I am reading section 20, where it is mentioned section 20 in middle of the 41 paragraph.
Yes, yes.
20 therefore has to be construed in a manner which would avoid such an anomaly and hardship both as regards to the litigants as also by placing a pointless fetter on the part of the court to punish for its contempt. Now, in the same page, last paragraph 44.
Hmm.
So procedure, who can file contempt suo motu, and these are been mentioned. I am not going into it. And now, your lordship, I am taking it to para 45, page 19.
19.
Yes, 19. What is the role of the party who wants to bring the contempt of court act? The role of such a party who brings a petition for proceeding to brings a contempt and activates the court's machinery is merely that of an informer. And next, para 46, in exercising its jurisdiction to punish for contempt, the courts in India do keep in mind the benefit that could accrue to the petitioner informer if he is a party to the parent proceeding out of which the contempt arises upon implementation of the order alleged to have been willfully disobeyed. Now, your lordship, I will take to paragraph page 21, paragraph 53. They have considered the point of limitation. Page 21, paragraph 53.
53.
Reverting to the point of limitation, even in a case of petition disclosing facts constituting contempt, which is civil in nature, the petitioner cannot choose a time convenient to him to approach the court. The statute refers to a specific time limit of 1 year from the date of alleged contempt for proceeding to be initiated, meaning thereby, as laid down in Pollock said, that the action should be brought within a year and not beyond, irrespective of when the proceeding to punish for contempt are actually initiated by the High Court. And they says that it is a original proceeding. And para 55 on the same page, last paragraph, the act which is a special law on the subject of contempt does not expressly or by necessary implication exclude the applicability of section 4 to 24 of the Limitation Act 1963. This court in state of West Bengal versus Kartik Chandra Das has held that in terms of section 29(2) of the Limitation Act, provisions contained in section 5 of the Limitation Act can be called in aid by a party who seeks condonation of delay in presentation of an appeal under section 18 of the Act. Similarly, in exceptional cases, provisions like section 12, 14, 17, 22, etc. of the 1963 Limitation Act could be invoked to seek exemption from the law of limitation, which is distinct from condonation of delay. In an appropriate case, it would be open to the party who has not petitioned the court within the period of 1 year, as stipulated in section 20 of the Act, to seek exemption from the law of limitation in line with the principle following from Order 7, Rule 6 CPC, by showing the ground upon which such exemption is claimed. We have no hesitation to hold that in a case where a civil contempt is alleged by a party by referring to a continuing wrong, breach of, and such allegation prima facie satisfies the court, the action for contempt is not liable to be nipped in the bud merely on the ground of it being presented beyond the period of 1 year, as in section 20 of the Act. Applicability of the principle underlying Order 7, Rule 6 CPC for granting exemption would only be just and proper, having regard to the objects and purpose for which the jurisdiction to punish for contempt is exercised by the courts. If, of course, the court is satisfied that the benefit of such an exemption ought to be extended in a given. At the same time, it must be remembered that the court cannot grant exemption from the limitation on equitable consideration or on a ground of hardship. Inspiration in this regard may be drawn from decision so and so. Para 56. A caveat needs to be added here for a continuing wrong breach offense to be accepted as a ground for seeking exemption in an action for contempt. The party petitioning the court not only has to comprehend what the phrase actually means, but would also be required to show from his pleadings the grounds resting whereon seeks exemption from limitation. Should the party fail to satisfy the ground, and on that ground, I am saying it is a continuing wrong. And here the annual increment has been sought for to get the pensionary benefit.
Mr. Bahali, Ultimately, what was held in this case?
Ultimately, because it is a property dispute and there is a fraud in the property dispute, ultimately court held um, para 88 conclusion para 89. For the foregoing reasons, we conclude that the High Court exceeded both its review and contempt jurisdiction. The impugned order is thus set aside, and the judgment order of the division bench in the contempt appeal and the letters patent appeal is restored. The appeal succeed and are allowed. But there was a property dispute and there was a review was entertained. But here the court has also given the power to exempt from the limitation if the petitioner shows the grounds.
Sir, exemption of limitation is something different from condonation of delay.
Your lordship is correct, but here says in contempt proceeding, court can exempt the limitation under order 7 rule 11 of the CPC. And here in the case, they have sought for a clarification from the law department, which is awaited, and it is pensionary benefit because petitioner has been deprived of from getting the pensionary benefits, higher pensionary benefit, because of the non-payment of the last annual increment before his retirement. And in the payment of annual increment, that is well settled by the Honorable Apex Court. I have cited that in the writ petition, that if a person is retiring on the day and the annual increment falls on the next day or before that date, he has to be accorded with that annual increment.
Mr. Bahali, have you taken that ground of continuing wrong?
Yes.
Where have you taken?
Yes, your lordship, kindly.
Or you are just making a submission?
No. Kindly have a glance to my IA, para 4. That the petitioner is an old and ailing retired low-class employee and living in a financial distress condition and retired from service 31/3/2014 and on several occasions visited the office of the contemptor and asked about the status of the grievance as per the direction of this honorable court in writ application, and in response to it, the contemptor time and again assured the petitioner that the opinion and clarification was sought for as Annexure 3 from the law department and requested the petitioner to await for it for some more time. And the petitioner, being convinced, remained with an hope for positive response, and due to his old age and his deteriorating health condition and financial distress condition, awaited for the response of the law department as per the assurance given by the contemptor for such long time, but which held no result, the petitioner being faced unwarranted situation and after making financial and filed. Next para, that the petitioner, in pursuance to the direction of this honorable court, passed in the aforesaid writ application, made representation to the contemptor office by restored post on 14/12/2023, which was received on 15/12/2023, and as per the direction of this honorable court, the same should have been considered within a period of 8 weeks, 9/2/2024, and the said decision on the representation should have been communicated to the petitioner with a reasonable period thereafter, but no such communication was made to the petitioner on the matter by the contemptor, even after passing of a reasonable period. That the petitioner also tried to know the position and status of his matter from his end, but got disappointed, and as such the petitioner should have filed the aforesaid contempt if communication period not taken into consideration for calculation of limitation, but the petitioner filed the same on 12/5/2020, which causes a delay of so and so.
Petition, interim application has been filed for condonation of delay in filing the contempt petition. As the stamp reporter has pointed out that there is delay of 94 days in filing the contempt petition. When the matter was taken up on 17/10/2025, the Land Council for the petitioner took time to cite some decision whether the delay as shown by the stamp reporter can be condoned. Today, the Land Council for the petitioner, Mr. Bahali, placed reliance S. Tirupati Rao versus M. Linga Maya and others, reported in AR 2024 Supreme Court 3738, wherein the relevant part, he placed the relevant paragraphs which are as follows. जोड़ा को मैं fold कर दीजिए, सेवड़ा को ठीक ये कर दीजिए, है ना? The Land Council for the petitioner then refer to the pleadings in the interim application to justify that it is a case of continuing wrong oblique breach on the part of the opposite party contemner for non-compliance of the order of this court dated so and so, passed in WPC number so and so. Issue notice on the question of limitation, requisites for issuance of notice be filed within a week, speed post requisite matter will be listed 4 weeks thereafter. So cause if any, objection if any to the delay condonation application, be filed in the meantime, serving copy on the Land Council for the petition. Yeah.